my name is Juban, and recently I was asked by several clients, hey, can I share my idea with other people before I get patent protection? In other words, before I get a patent to issue, knowing that it takes 2 years to get a patent to issue from the US Patent and Trademark Office. So they asked me the question, can I share it with other people? The answer is no and yes. So the first thing you got to understand, you cannot share it with people because that's considered public disclosure. That's considered an act that puts time limits in place against which you have to file your patent in the US. Now, those time limits do not exist outside the US. So if you do disclose your patent to anyone publicly, or your idea that you plan to file a patent on, if you disclose it publicly, then you cannot seek patent protection in other countries because you have to have your idea on file before you disclose it. Also keep in mind in the US, it's a first to file system. So whoever goes to the patent office first and files on the idea is the winner in the race in terms of who is the one that's got the best rights once the patent issues. Also keep in mind that the US is a first to file system. However, it's not a first to file system if you stole your idea from somebody else. So if somebody is going and filing for patent protection in the US Patent Office, they have to sign an oath and declaration saying it is their idea, they came up with it, and they didn't take it from somebody else. And it's quite possible that two people are solving the same problem at the same time in two separate parts of the world. And whoever gets to the patent office first, that's the one that wins the race because both are legitimate inventors. Both came up with the idea on their own without stealing it from the other person. So, how do you prevent public disclosure from happening? That's what my clients ask me once I tell them they should not go file for patent protection on their own. And the main way that you prevent public disclosure from happening is by having a non-disclosure agreement or a confidentiality agreement in place. We can help you with those questions. We can help you put those agreements in place. The main thing you have to understand is those agreements have to be in place before you disclose your stuff to a third party. Even if the third party is someone that is helping you build your invention, you need to put them under a non-disclosure. Even if the third party is someone who is listening to you for the purposes of marketing the idea, you need to put them under a non-disclosure agreement. So, and also, if it's a third party who's interested in buying or you think you're pitching your idea to for the purposes of selling it, you definitely need to put a non-disclosure agreement in places. We have a whole video on what non-disclosure agreements are, the different kinds of things that should be in non-disclosure agreements, and when you should get them in place. So look for that video. Here's our contact info. If you have any questions, give us a call, send us an email. We'd be happy to help you out and give you some guidance. Take care.